Right. Well, we can still get them. Okay. I'm going to read fascinating facts about the founding fathers. To read the Constitution. Actually, I'm reading in, what is it called? Fascinating Facts about the 6 Founding Fathers.
Oh, I'll bet there are some.
I would imagine.
Look at they're pouring in, Molly. Come on, see, it's our show up.
It was mainly I don't want to look, like I'm dead on your video.
Oh, that.
I'm giving up on that because, can't cry like that.
You can.
It's a thing. Susan, a friend of mine, I said, you walk past the mirror when you're, when you're feeling good and you walk past it, who's the old person? And then you're like, oh, wait, that would be me. Oh, wait.
Oh, dear.
Okay, I will call this Constitution Day to order. I am so glad to be here among friendly faces, and thank you for coming to this Constitution Day lecture. Who knew that one of my new duties as Vice Provost is to produce a Constitution Day lecture every year, and typically it rotates among the units of Wake Forest, and to my knowledge, the library has never done it. And so I said to myself, who knows the most about the Constitution in the library? And I thought it was Molly, but she says it's not. But, right. Kimberly and Muhammad, forgive us. We all know each other. And most of us are librarians. And I know from being a librarian that the Constitution is very important to us. And I know that the First Amendment is very important to us. The Bill of Rights is very important. And look, we have our own Bill of Rights. So I asked Molly to do a lecture, and she graciously agreed. And so we are going to hear this particular spin on our wonderful Constitution, which you all have in your hands. This is a gift if you haven't gotten one already. Page 6, there are fun facts about our founding fathers. So that should be interesting. Okay, I give you Molly Keener, who is our scholarly communication librarian at ZSR.
Thanks. Welcome to Wake Forest University's 2014 Constitution Day lecture. As Vice Provost Sutton said in her introduction, I am Molly Keener, the scholarly communication librarian here at the Z. Smith Reynolds Library. It is my honor to be speaking to you today on a subject that some of you may not know much about, although we are a librarian-heavy crowd, so you should know some of what I'm about to say. And which, until I was asked to give this program, I knew about, but not nearly as well as I do now. And as Lynn said, she assumed I knew the most about the Constitution. I know a heck of a lot about copyright in the Constitution. The rest of it, not as much. So copyright, sure. The rest of it, not as much. But before I get started today, just a quick note about the slides. Rather than stand up here and read the 6 articles of the Library Bill of Rights to you, which would be rather dull, they will be on my slides, rotating continuously throughout my talk. You will see, as you read them and listen to me, that the major issues that I'm bringing before you today are all addressed by the articles of the Library Bill of Rights, often by more than one. Each article will rotate every 30 seconds. Hopefully that will give you enough time to read them, but with a slow enough rotation that you won't find them too distracting. So, without further ado, the other Bill of Rights, Constitutional Foundations of Librarianship. As I'm sure we all know, our country was founded on the principle of liberty. Unlike many other countries, ours did not come together because of shared territory, religion, culture, or ethnicity. Although there are many different ways to define liberty, the United States Constitution, and shortly thereafter the Bill of Rights, aimed to define the principle of liberty as it was understood when our country was founded. This spirit of liberty, particularly as it is codified in the First and Fourth Amendments, addressing freedom of speech and right to privacy, is integral to American librarianship and to our intellectual freedom. We librarians actually have an entire manual on intellectual freedom to help us put into practice the ideals our profession acknowledges are vital to our democracy. As the introduction to the Intellectual Freedom Manual notes, intellectual freedom is freedom of the mind, and as such, it is both a personal liberty and a prerequisite for all freedoms leading to action. Intellectual freedom can exist only where 2 essential conditions are met. First, that all individuals have the right to hold any belief on any subject and to convey their ideas in any form they deem appropriate. And second, that society makes an equal commitment to the right of unrestricted access to information and ideas, regardless of the communication medium used, the content of the work, and the viewpoints of both the author and the receiver of information. Now, that said, neither of these serve as an American Library in the room know, we commonly refer to the American Library Association, has not defined intellectual freedom absolutely. Rather, through various channels, ALA has promoted various principles to foster an environment favorable to intellectual freedom without rigid standards. The beginning of our profession's stance on and defense of intellectual freedom was born from librarians' opposition to the censorship of materials. Multiple censorship efforts in the early 20th century led to the 1939 adoption of the Library's Bill of Rights, the precursor to the present Library Bill of Rights, the articles of which you've been noting on the screen. Shortly thereafter, ALA created the Intellectual Freedom Committee, and later, in 1967, it created the Office for Intellectual Freedom. As you would hope, principles affirmed in the Library Bill of Rights have evolved over time, and as our information issues continue to change, they will evolve again. However, the issue that served as the seed for libraries' acknowledgement of the critical role we play in protecting intellectual freedom, the issue of censorship, is frustratingly still an issue today, and is the first major issue I'm addressing. Book challenges and attempted book bannings, while fortunately not a common issue in academic libraries, are all too frequent occurrences in school media and public libraries. If you went to public school in the United States, I'm willing to bet that your school highlighted Banned Books Week in one way or another. This year's Banned Books Week is right around the corner, starting this coming Sunday, September 21st. So, as an aside, I encourage you to read a banned book in the next week in solidarity. We have a library full of them if you need them. Books are challenged for a variety of reasons, although the most common reasons shouldn't come as a surprise. Books are often challenged for being sexually explicit, containing offensive language, and being unsuited to any age group. I personally find this last reason, that any given book could be deemed inappropriate for anyone, regardless of age, to be both comical and depressing, as it shows just how deeply ideas can scare some people. Most challenges come from parents, more than any other group, and in 2013, there were 307 challenges reported to the ALA Office for Intellectual Freedom. The most frequently challenged book was the Captain Underpants series by Dav Piley, followed by Toni Morrison's The Bluest Eye and Sherman Alexie's The Absolutely True Diary of a Part-Time Indian, which is very good, by the way. Just these three titles demonstrate that challenges to books on library shelves and in classrooms are not restricted to children's books, or books about magic, or books that are classified as popular fiction, not literary fiction. Challenges cross all genres and ages, sadly. They also cross all libraries. As I noted earlier, challenges in academic libraries and college classrooms are rare, but they do happen. From 2000 to 2009, there were 5,099 challenges reported, and of those, 114 were to materials in college classes and 30 to academic libraries. Given that most challenges are initiated by parents, the ALA has responded by stating, in Free Access to Libraries for Minors, which is an interpretation of the Library Bill of Rights, that librarians and governing bodies should maintain that parents, and only parents, have the right and the responsibility to restrict access of their children and only their children to library resources. While certainly there are many parents who do elect to have their children read alternate materials, a common option in classrooms when parents object to a title on a reading list, those who make formal challenges risk more than they may realize. As the National Coalition Against Censorship's Kids' Right to Read project states in its censorship is about more than a single book. Each time a book is removed, it reinforces the idea that books and ideas are off limits if someone doesn't like them. Challenges to library materials are not restricted to books. The second major issue I wish to address today is freedom of speech and patron privacy. Obviously, privacy is of critical concern to our society of late, especially online. Library patrons' rights to access information of their choosing without fear of being judged or held accountable, barring illegal activity, of course, have been challenged by laws enacted post 9/11, most notably by provisions in the USA Patriot Act. Librarians will generally comply with court-issued warrants for patron records. On the whole, we do tend to be a legally responsible bunch. But the USA Patriot Act expanded authorities' powers to obtain information, sometimes bypassing court orders, potentially including library patron records, putting patron privacy in jeopardy. You may recall the case of the 4 Connecticut librarians who waged a months-long battle against the USA Patriot Act, refusing to hand over patron records without warrant, and who were initially gagged by the FBI from speaking about their efforts. As I said, while we are legally responsible, we aren't unwilling to take a stand to defend patron privacy. The American Library Association honored the Connecticut 4's stance in 2007 by awarding them the Paul Howard Award for Courage. It is a fundamental component of free thought. In a library, the subject of users' interest should not be examined or scrutinized by others. We might give you guidance on which sources would benefit your search and which are authoritative, but we won't tell you not to look at something in an attempt to censor you. Libraries don't keep records identifying patrons' past checkouts or track your online search history. As my colleague Chelsea Rowell so wonderfully noted when we were chatting about my presentation, libraries aren't building amazing algorithms like Amazon, not because we can't technologically compete, we can, but because we don't track patron data. Libraries not only don't track materials our patrons use, we also don't track access to patrons. While many libraries do have rules governing public viewing of potentially offensive sites, such as pornography, and sometimes must take steps to comply with laws that serve to protect minors online, we strive to, on the whole, provide unfettered, unfiltered access to our patrons. For many public library users, the library's internet access is their only internet access. We provide them a means to access applications for jobs, applications for social support services, email, news, sports, social networks, and whatever else they need and want. Libraries are serving a critical role in bridging the digital divides that exist in communities across our country by providing access to the internet. Speaking of the internet, I want to turn to my final major issue today, that of network or net neutrality. This issue goes far, far beyond libraries, but we understand more so than some the dangers of undermining net neutrality. Right now, if you were to go online, the ZSR website, Etsy, Netflix, your personal website, and any other site you wish to visit are delivered to you by your internet service provider or ISP at load faster than others, but that's site specific, not ISP dictated. That may be changing, though. Following a court ruling earlier this year that struck down rules established by the Federal Communications Commission in an attempt to preserve network neutrality, which is a foundational principle of the internet and which has contributed to making the internet the wonderful, wild, freewheeling space that it is today, ISPs may begin to charge for an internet fast lane of sorts. Sites from organizations that pay up would load faster than sites from those who do not or cannot pay. Competitors' sites may also be relegated to the slow lane. Universities, libraries, individuals, nonprofits, artists, musicians, basically anyone who isn't a wealthy tech company or big firm would, in essence, see their site slow down. So, Netflix movies would load faster than library help videos. Facebook would load faster than a scholar's blog. Amazon would load faster than Etsy, and so on. Of concern to academic libraries, and really all libraries, but we're obviously in an academic setting, so my thoughts tend to skew toward academic libraries. If library content providers, such as EBSCO, decide to pay content, who would cover that increased cost? The content providers? Maybe. It's more likely that those costs would be passed on to libraries, which already struggle to pay for content for faculty and students need. Thinking beyond organizations and institutions, if you are a scholar in a niche field, or an individual or a group that holds a marginalized viewpoint, you could be all but silenced by the slowdown. Think about it. How long do you wait now for sites to load? If it's too slow, you probably just move on. If the Federal Communications Commission does not reclassify broadband as a utility or a common carrier service, which is how telephone lines are classified, then the FCC cannot issue stronger restrictions on fast lanes. And that reclassification is controversial. I admit, I don't fully understand the controversy, and my father-in-law used to be in the telecommunications industry and tried to explain it. Still didn't quite understand why it's so controversial. But I do know that issues we are already seeing play out across the digital divide could get much, much uglier as public libraries, academic libraries, and other organizations that strive to bridge that digital divide by providing public internet access would be hosts to grumpier patrons whose searches take longer because they are accessing resources from companies that likely cannot afford to pay for fast access. As you can hopefully see, the principles of access, free speech, and privacy are foundational in both the United States Constitution's Bill of Rights and the American Library Association's Library Bill of Rights, which I do hope you've been noting. As ALA states, equity of access means that all people have the information they need, regardless of age, education, ethnicity, language, income, physical limitations, or geographic barriers. It means they are able to obtain information in a variety of formats, electronic as well as print. It also means they are free to exercise their right to know without fear of censorship. Attempts to restrict access to materials, to concerns over protecting privacy, to the fundamental equality of the internet, demand our attention and our engagement to protect and defend all people's right to information. Advocacy for our society's intellectual freedom is integral to librarianship and to those of us who are librarians. Thank you.
That was truly beautiful, and reminded me why I'm proud to be a librarian, and reminded me why sometimes when I talk to young people people, I describe librarians as freedom fighters, and they don't understand it at all, but the founding fathers would understand it, right? So Molly doesn't want you to quiz her on the.
I'll flip.
But if you have any comments to share at all, or question each other, it's a good time to do so.
Chris.
Molly, I know that you can share your views with the FCC about net neutrality. How can you contact them?
So the